What's going on, everybody? It's been a while, so this is part 13, I believe. I could be wrong. For my carry permit process. So, if you obviously watched any of my other videos, you would know I submitted to my chief for a carry permit almost a year ago, and I was denied, and then I appealed his denial, which you got to do anyway, to the county court of Gloucester County, South Jersey. And I was also denied there, and that was on December 13th, 2017. Though the written denial didn't come out till the next day, the 14th. That led me to, if you watch the other videos, me and my friend Mark, who was denied the same day, we got together with Jay, who is very good at what he does when it comes to researching case law and historical information. We then started to raise some money, and we filed our appeal, our notice of appeal, to the appellate division in Trenton. So me and Mark, within days of each other, submitted our notice of appeal, and we had to wait until we got a brief schedule. That brief schedule told us when we needed to submit our brief, aka our argument, to the appellate division. We finally got our brief schedule. Mark was like maybe a week and a half behind mine, and we both submitted our briefs, about 60 some pages of our legal brief, and we submitted pro se, no lawyer, but we did have a lawyer check out some things in our brief. Not the argument itself, but the format. Now that didn't go too well. So this is why I wanted to update everybody where we stand. I spoke to directly my case manager, who's running, or handling my case, and I was told multiple times that they give leeway to people who are pro se when it comes to how the brief is written and what they will accept and what they won't. And they said if it's major, they have to kick it back, but if there's small things, nitpicking things, they'll let that go because they know that you're pro se and no lawyer. There's also a statute or law, I don't know, whatever, that actually requires them to accept our brief because we're pro se. As long as we meet the minimum, basically, of what's required. That said, I got a letter back within, it seemed like days actually, from the time they officially received my paperwork to the time I got this letter back from them was very short. I mean, it was probably 4 days, maybe even 3. So they didn't even really get into it, in my opinion. But the paperwork said that I had 15 days to fix a list of things that they wanted fixed on my brief, that it was not acceptable. My list, they listed 12 things that were wrong. Now, this is where it gets nitpicking, which is totally against what they told me, and by statute, law, whatever you want to call it, is against their own policy because of being pro se. Some of the stuff was my font size. Like, for an example, I might have had a 14-point font and they wanted a 12-point font. Another thing was they only wanted 26 lines per page, and I had 31 lines per page. The title of it was wrong. I didn't sign the back sheet, which I didn't even know I had to. A whole bunch of little nitpicking stuff. So Jay, thankfully, he looked at it. I sent him what they wrote up, and he fixed my brief. Now, as a heads up, because me and Mark's briefs were almost identical, I told Mark, so Mark had a head start and Jay had a head start, kind of fixing his brief as well, anticipating that he was going to get the same kickback letter. Now, weeks went by and he still didn't get the letter that I got, so he actually thought that his was accepted, which would have been funny because our briefs are like 99% the same. Only difference is I'm in team 1, my case is in team 1, and his case is in team 2. Maybe they're a little bit lenient over there. But within days of my 15 days expiring, he got his letter. Funny thing is, he only had 11 things wrong with his. But Jay again stepped up and reworked his brief to fit exactly what they wrote up, and he just sent his back. So we are now waiting for what the appellate division is actually going to do. I have called the appellate division, left a message for my caseworker, or whatever you want to call her, asking for any updates, what's going on, and I have not got a response. I know they got it because I did the way I sent my brief, I got it was tracked for one, it was signed for, and I had a return receipt. So I know they got it. I know they signed for it. And I know they got it within the 15 days that was required. But I would still like to know where it stands. But she didn't call me back. I know Mark just got his stuff sent out a few days ago, so I'm going to wait before we know anything on his end. We also, Jay also submitted paperwork for a Freedom of Information Act to try to get some information regarding the Sicardi rule, which basically is what's fucking us in New Jersey. Because Sicardi's case and Drake's case, the combined of those two, and another case, I can't remember the name of it off the top of my head. Jay's way better at that than I am. They're kind of like the controlling case of what's going on in New Jersey, because honestly, they don't care what the Supreme Court has ruled, because they feel that it didn't specifically target Jersey on the ruling, you know. However, what they fail to realize, I think is what's going to slap them in the face, is what our brief is going after. Our argument is not what all other arguments in New Jersey have went after in the past and always seemed to lose. They always would attack justifiable need as a whole and try to get rid of the statute completely as unconstitutional. Well, and they try to claim it's long-standing, New Jersey is long-standing law, and that's the only reason why it's allowed to stand. Well, really, it's not long-withstanding. It's only been since the 60s. So, that's really not that long ago for it to say that it's like a long-standing law. Really think about it, not to be insensitive, but, slavery, which is a horrible thing, so don't get me wrong, but slavery was taken as being a long-standing law, common law, and it was okay at the time, and it was overturned like it should. But you can't just say something is legal because it's been on the books for so long. That's a stupid argument. But we also found during the historical analysis of all of the New Jersey cases that the whole process on how justifiable need came about didn't even follow the right procedures. Therefore, it's, in layman's terms, it's an illegal administrative code, but they somehow got it through. Anyway, the Heller decision in 2008 and the McDonald in 2010 both said that you can no longer decide whether or not someone can have their Second Amendment rights or not on a case-by-case basis, and that future assessment by judges, if the Second Amendment is worth it, basically, means that it's not a guarantee at all. But since it is a guarantee, they can't decide on a case-by-case basis, which completely shoots down New Jersey. It is undeniable. 2 Supreme Court cases that are relatively new both said a state cannot deny or issue permits on a case-by-case basis. On the other hand, New Jersey prides itself and even brags that it does just that. So, we are pointing out that fact. Now, if New Jersey turns around and says they're still going to do that, then they're 100%, they have to put it on paper that they are violating 2 Supreme Court cases. Supreme Court law, technically. It's the law of the land. And there's 2 cases that say that they have to do that, or they can't do that, I should say, in this matter. So either they have to go against the Supreme Court, which is a violation, and we can sue them over that, or they have to agree and they have to change their law. They're actually stuck, between a rock and a hard spot. Because no matter what they do, we have course to continue our fight. I'm not the best to go about the legal talk of it, but Jay's way better and at doing all that stuff. But we have a very, very, very solid argument that has never been brought up. This type of case has never been brought in New Jersey, and that I know of hasn't been brought up anywhere else in any other circuit. So with the combination of going after that, we are not trying to sever or get rid of justifiable need. What we're really trying to do is to say the Siccardi rule and the case-by-case determinations must be thrown out. That has to go. And that justifiable need needs to be what it was originally intended for. And that was for lawful purposes. And the Supreme Court has ruled that self-defense is a lawful purpose. So in hindsight, if you apply for a carry permit anywhere, your only reason you need to give to anybody is the fact that you want to defend yourself and your family. You shouldn't have to be able to supply a written letter detailing who you got to defend yourself against or point out the threat, because no one can really do that. They want us to, be future tellers or something to be able to get a permit. So it's really a de facto, because when I submitted my case originally, and it's coming up on a year soon, I actually had a reason, okay, in which, if you watch my videos, I'm not going to post my transcripts or not, anything like that, but I have it in writing, what the judge said, and what the prosecutor who was there representing New Jersey said. And I'll paraphrase it. The prosecutor said he agreed with me, and he said if I was in his shoes, I would want one too, meaning a permit. The judge also came out and said that he agreed that I actually had a threat and does not deny that there was a threat, but the threat was vague. And though the threat was vague, the threat would always be there because of the situation and what the threat was. So I would technically, in his eyes, I would always have a vague threat looking over my shoulder, if you want to call it that. But yet that wasn't good enough for New Jersey. So when my threat, if ever, decided to actually come true, and I am attacked, or my family is attacked, hurt, injured, even killed maybe, because I can't defend myself, is the judge liable? Probably not. Can I sue New Jersey over my life? Probably not. Just some probably stupid ass law out there saying that they can't be held liable. So who's the one who pays the ultimate price because I wasn't able to defend myself? So when you actually have a reason in New Jersey and you still get denied, then you really know that the law that they have in place, or the administrative law that they have in place, is friggin' bogus. It doesn't mean anything because they don't follow their own rules. I have it in writing that states someone who has a restraining order or a protective order issued by the court that shall be deemed to be justifiable need. And though I gave the judge and the chief copies of the restraining order and the letter from the prosecutor who originally prosecuted the case years ago, it wasn't good enough. So the whole justifiable need scam of if you show a just cause or a reason to fear for your life will give you one, it's a lie. I mean, there was people that were friggin' kidnapped okay? And they didn't get their permit. You know, so the whole thing in New Jersey, it's really screwed up here, and we really need this case to go well. And I will post a link in this description of our GoFundMe page, which we're raising that money for the fight, not only at the appellate division, but if we have to go to the New Jersey Supreme Court, and if possible, if need be, the U.S. Supreme Court. So if you can and you want to help the cause, you know, $5, whatever, or even sharing the link, anything that you can do that might help us fight back against this stupid law that New Jersey has, that you basically have to be a victim before you can even be considered to get a carry permit, is absurd. And in most cases, even that doesn't matter. So, again, thanks everybody for watching. This was a little bit longer than I planned on it being, but until next time, peace.